Welcome to my presentation on the critical review of arbitration and adjudication in construction disputes. ADR method in construction include arbitration and adjudication. All these approaches have merit and drawback and are suited to particular types of disputes. Arbitration under Arbitration Act 1996 in England and Wales allows both parties to select a neutral arbitrator and make a binding decision in a private and flexible setting. In complex disputes where technical expertise is required, this method is particularly valuable. Adjudication is an expedited interim process under the Housing Grant, Construction and Regeneration Act 1996 and is binding, preventing delays in construction work. This critical review examines the advantage, limitations, and implications of arbitration and adjudication in construction disputes. It compares each with traditional litigation to demonstrate their effectiveness and role in the industry and provide insight for stakeholders on how to apply each ADR method. Arbitration in construction disputes. Arbitration has become a standard ADR method in the construction industry because it is structured, private, and expert-driven. Under the Arbitration Act 1996 in England and Wales, arbitration is defined as the presentation of a case by both parties to a neutral third party, whose decision is binding. The structured yet flexible framework of arbitration is suited for the construction industry, where technical knowledge is often required to understand project details. The advantage of arbitration in construction disputes is the ability to select arbitrators with particular expertise. Unlike judges in traditional courts, arbitrators may be chosen based on technical or legal experience. For instance, in disputes involving complicated engineering concepts or complex contract clauses, as industry, qualified arbitrator can make more nuanced and knowledgeable decisions, according to Wells, 2009. This specialized insight may improve the outcome and give both parties confidence that the resolution is fair. Another advantage is confidentiality. Unlike the litigation that is open to the public, arbitration proceedings are closed and confidential, so no sensitive information becomes public record. It is particularly important in construction disputes involving reputational risk and proprietary information. The confidentiality of arbitration may preserve business relationships by allowing parties to resolve disputes privately without public scrutiny or competitive disadvantage. Flexibility in procedural matters is another feature of arbitration, and unlike the stiff protocols of court-based litigation, parties to arbitration can agree on procedural details like hearing location, timing, and format. This flexibility extends to arbitration rules themselves, since parties may tailor proceedings to their particular needs and thus speed up resolution if necessary. This gives both parties considerable autonomy in defining these parameters under the Arbitration Act 1996, according to Indukogiri and Russell, 2005. All these advantages aside, arbitration has limitations in terms of cost and finality of decisions. Although arbitration costs less than litigation, expert testimony, lengthy proceedings, and administrative fees can add complexity to cases. In high-stakes construction disputes, these expenses may exceed litigation costs and may make the matter unobtainable for smaller contractors or subcontractors. Although another downside is the limitation ability to appeal arbitration decisions. The binding nature of arbitration generally helps settle disputes but can be problematic if one party believes the decision was wrong. The Arbitration Act 1996 provides for limited appeal grounds, with challenges only allowed where there are procedural irregularities or issue of public policy, according to Van Hassel of 1997. So arbitration does not create legal precedents that would limit its future applicability to guide future disputes. Adjudication in construction disputes. Adjudication can help resolve construction disputes quickly and affordably, and can prevent delays on site. As a matter of law under the Housing Grants, Construction and Regeneration Act 1996, the Construction Act, adjudication was introduced for the construction industry to meet the need for fast, binding decisions. Usually, this method is used to settle payment disputes and issues with project timelines, so work can continue while disputes are resolved. As a speedy process, adjudication has advantages of reduced time, reduced cost, and continuity of project operations, according to Marshall 2012. Speed is among the main benefits of adjudication. The Construction Act mandates that adjudicators make a decision within 28 days of receipt of the case unless both parties agree to an extension. That time frame helps parties settle disputes quickly, especially in construction where delays can be costly and disruptive. The rapid resolution also avoids lengthy disagreements that could stall the project, so construction can proceed as planned. This speed contrasts with litigation, which may take months or years to conclude. The other benefit of adjudication is its economic value. This short timeline and procedural simplicity save attorneys' fees and administrative costs and make it an attractive option for contractors, subcontractors, and other construction project participants. Compared with arbitration and litigation, which often require extensive preparation and large amount of legal representation, adjudication is relatively inexpensive and suited to the budgets of most construction stakeholders. Accordingly, adjudication spares parties the financial burden of other dispute resolution methods. This binding but interim nature of adjudication is also useful for keeping projects on schedule. The adjudicator's decision is binding and enforceable but provisional in that either party may contest it later in arbitration or litigation if they are unhappy with the result, according to Wells, 2009. This temporary binding allows the project to continue as planned and allows both parties to work together, knowing they can seek further resolution if necessary. The court generally enforce adjudicator decisions promptly, which help the process maintain project continuity. But adjudication is also limited because it is interim and potentially incomplete. This short time to make a decision means that the investigation into the dispute may not be as thorough as in arbitration or litigation. That may produce expedient decisions that fail to resolve the underlying issue and potentially cause additional disputes or appeals, according to Indicori and Russell, 2005. Its temporary nature can thus create some uncertainty as parties may return to arbitration or litigation for a final resolution, which may take longer and cost more. A third and final limitation is enforcement complexity. The decisions of adjudication are binding but can be challenged where one party refuses to comply. Sometimes enforcement of an adjudicator's decision becomes difficult where the opposing party is resistant or has ground to challenge the decision in a higher forum. This may cause additional litigation and negate the cost and time benefit that adjudication initially provided, according to Marshall, 2012. But despite those limitations, adjudication remains an important tool in resolving construction disputes, especially when project timelines matter most. With its emphasis on speed and cost efficiency, it is the right choice for disputes which must be resolved immediately without stopping the project. Ability to contest the decision later through arbitration or litigation also gives parties flexibility to pursue a final and comprehensive resolution later if needed. Comparing arbitration and litigation in construction disputes. In construction disputes, both arbitration and litigation may be used as dispute resolution method but differ greatly in speed, cost, confidentiality, and procedural control. Every approach is strong and weak, and which one to take is often dependent on the particular needs and priorities of the disputing parties. Speed is among the main differences between arbitration and litigation. Arbitration typically ends much sooner than litigation due to the absence of courts, scheduling delays, and backlogs that can significantly extend litigation timelines. Arbitration flexible timelines allow parties to agree on a timetable and work with arbitrators who can prioritize their case. This speed is especially useful in construction where disputes can be costly, according to Indocure and Russell, 2005. But litigation can take months or years to resolve due to the procedural formalities and potential appeals. A less costly option when project timelines are critical. Confidentiality is another critical factor for arbitration. The delays of the case remain secret during arbitration proceedings, which is advantageous for companies wishing to protect proprietary information or sensitive business details, according to Wells 2009. Especially construction companies take advantage of arbitration's confidentiality because its release in litigation might harm reputations or reveal sensitive contractual details. But litigation is a public process. The public may see court record which could damage a company's reputation as well as reveal important technical or commercial information. This transparency makes litigation less desirable for parties that value secretion in dispute resolution. The benefit of arbitration largely outweighs the disadvantage in cost in this area. Arbitration may be faster than litigation but costly, especially in construction disputes. Arbitrator fees and other administrative and legal costs can make arbitration nearly as expensive as litigation if expert witnesses are needed. Yet, a quicker outcome in arbitration may reduce overall costs relative to the long-term cost of a long court case, according to Brunner, 2022. Though long and costly because of procedural requirements and appeals, litigation is usually cheaper because it follows a process controlled by the court system. The advantage of expertise in arbitration may be significant for disputes involving technical construction. Arbitration allows parties to select industry-specific arbitrators who may make better informed technical decisions. For example, an arbitrator trained in engineering or construction law may understand a complex project contract better than a generalist judge in court. This expertise enables more accurate and context-sensitive decisions. Meanwhile, litigation assigns cases to judges based on availability rather than specialization, which may mean that decisions are less tailored to the technical details of construction disputes. The biggest disadvantage to arbitration is the limited appeals rights. Arbitration awards are final and binding under the Arbitration Act 1996, with limited appeal grounds available for procedural, regulatory, or matters of public policy, according to Van Hasselt, 1997. This finally is advantageous to parties seeking conclusive resolution, but disadvantageous to parties wishing to retain appeal. In litigation, a more expansive right to appeal is available, where parties seek further review of the decision if they believe it was wrong. Such an appeal process allows for oversight and correction but may prolong the dispute resolution and add to project delays. Another difference is the procedural control. Arbitration gives parties considerable latitude in procedural matters such as timelines, arbitrators, and rules of procedure. This flexibility enables the dispute resolution process to be adapted to the parties' needs and may speed decision-making and reduce administrative burdens, according to Makin and Finlaleri, 2014. In litigation, In litigation, however, the court establish procedural rules and time frames which are rigid and may not meet the demands of construction dispute. Critical assessment of arbitration in construction disputes. Some advantages makes arbitration a popular choice for industry stakeholders in construction disputes. This is a benefit because arbitration proceedings are private. Sensitive information is not made public. Discretion like this can protect corporate reputations and secret project details, valuable in competitive industries such as construction. Arbitration removes the public liability associated with court proceedings by resolving disputes privately. The other strength of arbitration is specialized expertise. On more complex construction cases, parties may select arbitrators with technical knowledge of engineering, architecture, or construction laws to make more informed and contextually appropriate decisions. This technical understanding may facilitate better dispute resolution because industry familiar arbitrators understand construction contracts, project phases, and standards. In addition to its procedural flexibility, arbitration enables parties to tailor the process from selecting arbitrators to setting timelines to meet project demand, according to Makin and Ferrari 2014. But arbitration is limited. One potential downside is cost. Whereas arbitration may be faster than litigation, complex disputes may still be expensive. Arbitrator fees, expert witness costs, and administrative costs can make arbitration as costly as or even more expensive than litigation in some instances. Such costs can be prohibitive for smaller construction companies, making arbitration unaffordable as a dispute resolution method. Another limitation is the finality of arbitration decisions, which have limited appeal rights. Arbitration awards are binding and can be challenged only on procedural irregularities or public policy issues under the Arbitration Act 1996, according to Van Hassel 1997. Such finality is advantageous for parties seeking conclusive resolution but disadvantageous if an error is perceived in the arbitrator's judgment. In addition, arbitration does not create legal precedents, and its rulings only provide limited guidance for future cases compared to litigation, which may provide legal clarity in construction disputes. Critical assessment of adjudication in construction disputes. In the construction industry, adjudication is both fast and inexpensive. Unlike litigation or arbitration, which may take months or years to conclude, adjudication makes a decision within 28 days. Such speed is useful in construction where delays can mess with project timelines and cause huge financial losses. Because disputes are settled quickly, adjudication allows work to continue without pauses and is attractive to parties who want to keep momentum with a project. The other characteristics is the cost efficiency of adjudication. Its streamlined, interim nature makes adjudication affordable for smaller constructors and subcontractors. In contrast to arbitration, which is expensive in complicated cases, adjudication is inexpensive in reaching a binding decision, which financial access also makes it suitable for construction at all levels and promotes quick dispute resolution. All these advantages aside, adjudication is limited by its temporary binding character. Although executable, adjudication decisions are subject to challenge in later arbitration or litigation. This provisional nature creates uncertainty as parties may not consider the decision of a final one. Consequently, adjudication may also trigger further dispute if one party is unhappy with the result, according to Marshall 2012. This can limit the efficacy of adjudication as stand-alone dispute resolution because parties may still expend time and money in additional legal proceedings. Another limitation is the limitation time for investigation. A 28-day period may be expedient, but not sufficient to examine complicated issues. In construction disputes involving technical details or contractual details, this may be problematic as adjudication may not have time to consider all factors fully. Thus, the expedited process may sometimes result in decisions that do not address underlying issues and may produce incomplete or contentious outcomes. Wells, 2009. Case studies and legal proceedings. Examining case studies and legal proceedings provide valuable insight into how arbitration and adjudication function in practice, particularly in the construction industry. Two notable cases, Lesotho Highland Development Authority versus Impregilo SPA, and Bogus UK Limited versus Dahi Jehi, illustrate the distinct operational frameworks and implications of this dispute resolution method. In Lesotho Highland Development Authority versus Impregilo SPA 2005 UKHL 43, the UK House of Lords addressed the finality and limited ground for challenging arbitration award under the Arbitration Act 1996. In this case, the Lesotho Highland Development Authority disputed the arbitrator's interpretation of a contractual clause related to a major dam construction project. The House of Lords upheld the arbitrator's decision, emphasizing that under the Arbitration Act, arbitrators' decisions cannot be easily challenged unless there is a significant procedural error or public policy concern. This case highlights the binding nature of arbitration and demonstrates the limited ability of parties to appeal arbitration awards, reinforcing arbitration's role in delivering conclusive decisions for complex disputes, according to Macken and Fenlare, 2014. In contrast, Bogus UK Limited versus Dahe Jensen UK Limited, 2000, exemplifies adjudication's interim yet enforceable character. Bogus, a contractor, sought to overturn an adjudicator's decision favoring Adjudication over a payment dispute in a construction contract. The Court of Appeal ruled that the adjudicator's decision was binding and enforceable, even though it could later be challenged through arbitration or litigation. This case underscores the temporally binding effect of adjudication, which enables project continuation without delay while still allowing for further recourse if necessary. Importantly, the court emphasized that adjudicators' decisions are generally upheld, aligning with the Construction Act's aim of obtaining project momentum by providing immediate enforceable resolution. These cases highlight the distinctive roles that arbitration and adjudication play in construction disputes. Lesotho Highlands emphasizes arbitration's finality and limited appeal scope, suitable for complex cases where a conclusive resolution is needed. Conversely, Bogus illustrates adjudication's fast, binding yet interim resolution, essential for maintaining construction schedules. Together, this precedent affirms the value of both arbitration and adjudication as ADR method, with each suited to different stages and needs within construction projects. Conclusion: in construction disputes, arbitration and adjudication provide essential alternatives to traditional litigation, each suited to different types of conflicts and project needs. Arbitration offers a private, expert-driven and final resolution, making it ideal for complex disputes where confidentiality and technical understanding are crucial. Governed by the Arbitration Act 1996, it provides a legally binding outcome with limited appeal option, offering parties closure but requiring a commitment to the finality of the decision, according to Makin and Fenari, 2014. Adjudication, by contrast, is designed to provide a swift interim resolution that ensures project continuity, in line with the Construction Act, aimed to prevent work delays. With its 28-day resolution timeframe, adjudication is highly effective for managing immediate issues in construction. Although its decision may be contested later in arbitration or litigation, this flexibility allows adjudication to maintain project timelines while giving parties the opportunity for future review if necessary. Chappell, 2020. Ultimately, both arbitration and adjudication are valuable tools in construction, addressing different priorities. While adjudication excels in speed and affordability, arbitration is better suited for cases demanding comprehensive analysis and finality. The choice between them depends on the dispute nature, the project timeline, and the parties' need for finality versus flexibility. Other team members for the project are Folekemi Falade and Omaomi Orukoya. I am Jenwarus Ogwado. Thanks for listening.